as Chief Justice of India, it has been my very firm conviction that we need to take the process of justicing and the administration of law to the homes and hearts of people.
Thank you very much for those insightful words, Chief Justice. Of course, being a member of India's Supreme Court, a big part of your role is to adhere to very strict legal principles, which form the bedrock of the Indian Constitution. How then do you balance a strict adherence to these legal principles with the imperative to humanize the law?
Well, a large part of the work which judges do is to interpret the law. And the law uses phrases very often which are ambiguous, phrases of a very broad content and diversity in itself. And that is, I think, the essence of the task of judicial craftsmanship, to allow for an interpretation of the law which would facilitate achieving the purpose of the law and facilitate achieving the purpose in a manner which is consistent with constitutional principles. So if we are dealing with a case involving affirmative action and the law provides for affirmative action, the effort of the court would be to humanize the outcome of the case without doing injustice to the language of the law by using phrases or interpreting phrases which the law embodies in a manner which would further the ideals of the law, in a manner which is consistent with the Constitution. Because the task of a judge in a constitutional democracy like ours, the task of a judge is not just to promote adherence to the rule of law, but to promote the adherence to a rule of fair law, both in terms of its procedural implications and the substantive outcomes.
And of course, you mention one of your recommendations for humanizing the law, as you just mentioned, is courts making judgments focused on the effect of those judgments. Do you then believe that a commitment to humanizing the law necessarily entails an activist court?
Well, speaking for myself, I mean, that's possibly a matter of experience. I don't really believe in binaries of human existence. I look at the law and the function of the judge in more fluid terms. So when a judge is interpreting the law to give effect to constitutional values, or focusing on the effects of a particular interpretation as opposed to merely the purpose of the law, the judge is not really being an activist. When we call judges activists, it has a sort of a pejorative implication that the judge is trenching upon an area or domain which is reserved for the executive or the legislature. Now, as judges, we are deeply conversant with the fact and cognizant of the fact that there's so much that we can do, and so much which in a democracy governed by the rule of law and the separation of powers is meant to be done by the legislature, by our parliaments, by our state legislatures, and by the governments who are elected governments of the day. And we respect that distinction between what is assigned to the legislature, what is assigned to the government, the task of administration, and what is assigned to us, the task of adjudication. But having said that, therefore, I wouldn't really say that the work which we do is of judges who are activists. But I think it's a plain sense of duty, because when the Constitution established an independent judiciary governed by principles of judicial review, which we of course have imbibed from our common law tradition and which we have built upon, at the same time, I do believe that the work which you do is just a matter of plain duty and nothing more than that.
Of course, that's very interesting. You bring up the important aspect of the separation of powers and the roles of the legislature versus the judiciary. Of course, applying this to a very infamous recent ruling, the ruling on the Special Marriage Act last year, your justification for delegating the legislation of same-sex marriage to the legislature was that, in your own words, the judiciary cannot legislate. Do you believe that this principle is compatible with the judiciary's duty to humanize the law?
Well, of course, it is the duty of the judiciary to humanize the law, but equally when you humanize the law, you cannot disregard the law unless you strike down the law. In a country like India, which is governed by a constitutional principle of judicial review, the court has not merely the duty to interpret the law, but the authority in a given case to even strike down the law. Now, you call the judgment in the Special Marriage Act case infamous, but I'll just share with you what the real issue was. And I'm not here to defend the judgment, Because as a judge, I believe that when you deliver a judgment, it becomes the property of not just the nation, but global humanity. Therefore, it's for others to critique the judgment. But I'd just like to tell you this, that the Special Marriage Act was a law which was enacted by Parliament, and the purpose of the law was to allow for couples belonging to different religious faiths to enter into marriage. Now, the law uses the expression man and woman. So the law is very clear. It contemplates a marriage in a heterosexual relationship. It provides for a variety of other things, including succession, including things like which are the prohibited relationships which cannot enter into a marriage for men and women separately. Separate ages of marriage for men and separate ages of marriage for women. So what we felt was that nobody wanted the law to be challenged, because if the law was struck down, you'd be in a situation where there would be no governing principle allowing for couples of different faiths to get married, which the Special Marriage Act does. So here you have a law which specifically uses the words man and woman. Can the court then override the provisions of that law and read that as man and man or woman and woman? And we said we can't do it. Now, another aspect which I must emphasize is that the entire gamut or domain of marriage is governed by legislation in India across communities. Now, therefore, we felt that if you have to recognize same-sex marriages, this is something which has to be done by Parliament, which is entrusted with the duty of lawmaking. But I must also share with you that I was in a minority in that case on a certain specific aspect, because I believed that the court should recognize at least the right to form civil unions for same-sex couples until such time as Parliament stepped in and legislated on the subject. 3 of my colleagues didn't agree with us. They felt that even the recognition of same-sex unions was beyond the purview of the court. But having said this, and I'll leave the question with just this thought, that what happens in courts in modern democracies is not only to be looked at in terms of the substantive outcomes of a case. The court is involved in a continuous process of dialogue. A dialogue not only with the litigating parties, but a dialogue with wider civil society. And that's one of the reasons why we have now decided to live stream our important constitutional cases. Because as Chief Justice of India, it has been my very firm conviction that we need to take the process of justicing and the administration of law to the homes and hearts of people. People must understand that the smallest issues which come up before the courts attract the most serious of application of mind. And in this case, I do believe that between the date when we decriminalized homosexuality in Navteej Singh Johar and today, there's a wider societal acceptance of these relationships. And I do think, speaking for myself as a judge, that there is so much which has to be done by society itself and by other wings in a modern democracy. You cannot look to the courts to resolve every issue of dispute that may arise in society. It's important as judges that we draw the line and decide what legitimately belongs to our jurisdiction and what legitimately belongs to other wings of society, including civil society itself.
I just wanted to pick up on that point. Do you then believe that without the cooperation of the legislature and greater civil society, the law cannot be humanized?
Well, I do believe that, the legislature has performed a very valuable role in humanizing the law. You have a host of social welfare legislations. And that's not true only in India. It's true in South Africa. It was true in, say, the New Deal legislation, which came into the United States in the years of the Great Depression. So legislatures across jurisdictions, across civilizations and time have attempted to humanize the law. But having said that, there are obviously interstices which are left undefined by legislatures. Very often, legislatures look at the wider social good which the law has to follow. And in the pursuit of the wider social good, which legislatures legitimately follow, and we respect them for doing that, there is always the danger of individual cases leading to grave injustice. And I believe that is where the critical role of a judge comes in, to ensure that while you do not disregard the law, the letter of the law, you also craft your opinions and your remedies and your reliefs in a manner which would protect the ends of justice in a particular case. And there's a provision of the Indian Constitution which is very unique because it allows the court, the Supreme Court, to do complete justice to the facts of that particular case, and which we employ very, very regularly.
Thank you for that. I'd just like to expand the scope of our conversation to an international scale. I was curious as to how Indian courts take inspiration from international law and proceedings before international courts. So, for example, with the South African interim measures application against Israel before the International Courts of Justice. Do Indian courts look at such instances of intervention as positive or guard against overreaching their mandate under local laws?
Throughout our history over the last 75 years, we have extensively looked at international conventions, including in particular conventions to which India is a party. So you would find a very repeated reference to the Covenant on Civil and Political Rights, or Economic, Social and Cultural Rights. So we have never stopped short of looking at the emerging consensus in the international community while interpreting provisions of our own law. I'll give you just one example. The Convention on the Elimination of All Forms of Discrimination against Women was one of the key components of the decision of the Indian Supreme Court when we dealt with the protection of women against sexual harassment in the workplace, which eventually led Parliament to enact a law following a judgment of our court. So you would find in a whole host of areas, we have relied on international treaties, conventions to which India is a party, and sometimes even those to which India is not a party. The other area where we have relied on comparative jurisprudence, including jurisprudence from the UK, is judicial precedent, which is not in that sense international law strictly speaking, but we are adopting principles of judicial interpretation followed by other jurisdictions, including the UK, Australia, South Africa, countries in our own neighborhood, including Bangladesh and Nepal, the United States. So we look at a diverse set of international precedents with a caveat though, which is that all precedent, particularly judicial precedent, is born out of the specific cultural traditions of each society. So it's not that you can, transplant a precedent just bodily and implement it in your own society. You can accept it with modification, or you can build on it. In many areas, for instance, we have gone far ahead of, say, what the US Supreme Court or the courts in several other jurisdictions have done. And say the medical termination of pregnancy is a clear case where you have on the one hand Roe versus Wade being overruled in Dobbs, but in India we've gone far beyond the statement of law on the right to abortion.
I just wanted to elaborate a bit more on this point of comparative jurisprudence and comparative constitutionalism. Of course, us being here in the UK today, we have quite a unique constitution in that it's uncodified. How then do you think humanising the law looks like in the UK with our unique unwritten constitution as opposed to India with its entrenched written constitution?
Well, I wouldn't really want to dwell too much on this aspect, except to say that though the UK has an uncodified constitution, a lot of constitutional principle and the precepts which have emerged from the UK have emerged through constitutional conventions. And you would find, if you look at the Indian Constitution, that many constitutional conventions in the UK have actually found codification in the Indian Constitution. I'll give you just a couple of examples. The fact or the legal position that a speech which has been made by a member of parliament cannot be impugned or challenged in a court of law is a matter of constitutional convention in the UK. But that forms a part of a substantive article in the Indian Constitution. Or that a member cannot be made liable for a speech which was rendered in parliament finds codification in the Indian Constitution, matters of parliamentary practice. But we have gone a little beyond, say, the position in the UK, because we have, as a constitutional court, we have said that while an irregularity of procedure cannot be the subject matter of challenge in a court, the irregularity of procedure in Parliament cannot be the subject matter of a challenge in court, a substantive illegality can be the subject matter of a challenge. So we've, in that sense, to answer your question, we've built on the convention by recognizing the fact that the convention was codified in our constitution, and then we applied the constitutional yardstick of rule of law principles to say that there can be a challenge to a limited extent, which is extremely important.
Thank you very much for that response. Just a final question from me. We can't go through this event without mentioning what's going on at the moment. As we speak, India's general election results are being announced. It's clear that India's legal landscape is poised at a critical juncture. Given the judiciary's critical role in interpreting and enforcing the law to reflect and protect the values of a diverse democracy, how can India's judiciary balance independence, social justice, and minority rights in a politically charged environment while addressing public concerns about judicial bias?
You know, elections lie at the core of constitutional democracy in India, because by electing our representatives, we choose to be governed by the people whom we desire to be governed. The role of the judiciary is, on the other hand, very distinct. Judges are not elected in India, and for a reason. Judges reflect a sense of continuity of tradition, the continuity of constitutional values. And while we do respect the role of the other branches of government, the legislature, which consists of the elected representatives of the people, the executive, which in a parliamentary form of government owes its accountability to Parliament. The judiciary has a vital role to play in a democracy, which is that we reflect this sense of tradition, and we also reflect this sense of what the future of a good society should be. And I do believe that while elections take place as a matter of constitutional doctrine, as a part of our law, courts have a very vital role to play in maintaining that certain values are eternal to the existence of our society. And we do not have to really seek too far to find those values. Those values are laid down in our preamble itself. And the preamble to the Indian Constitution underlines those eternal values which should be protected by the courts under the rubric of the rule of law and the rule of a fair law. And therefore, I believe that, of course, during times of elections, the nature of the disputes which come before the court may be more politicized. Different kinds of disputes arise before the court. But at the end of it, when you have trained judges deciding these disputes, that allows for courts which will decide disputes on the basis of a settled tradition, a tradition of continuity based on constitutional precepts, as opposed to the passions of the moment.
Thank you very much. We have now reached the point in the event where we'll be taking questions from the audience. If you wish to ask a question, please raise your hand, and once called upon, you will be given a microphone. Please speak into the microphone from a distance and give it back once you have finished asking your question. I'd like to remind the audience that the Chief Justice of India is bound by judicial neutrality and sub judice rules. As such, he is unable to take questions on cases currently being considered by the courts or any questions which would challenge his neutrality. I look to the member just sat over here.
Hello, you can hear me? Yeah. Should I stand up? Okay. Thank you so much for speaking to us today. It was really great to be able to hear you, particularly today. And I really wanted to get when you talk about humanization and democratization through technology, I just wanted to ask your opinion on, I suppose the opposite effect of democratization of legal judgments is that they can become the source of a lot of misinformation and a lot of, I suppose, just like poorly popularized ideas of what your judgments are that are like put into tweets or put into articles that are spread around, and there's a public perception that's just not reflective of what your judgments have been. And particularly, for you, I think there are periods during, depending on the cases that you see, where there becomes a very active interest in your history and your the agendas that you carry and all of these things. Do you feel like there's a relationship with the public perception of the law and a judge's duty? And do you feel like that's something that's ever impacted how you approach your cases? And do you see any sort of areas of improvement you feel within either Indian education system or the way that we interact with the law that should make a judge's life easier in that regard in terms of public perception? Yeah.
I'd make a distinction between technology and the social media. Now, the social media is, of course, based on technology, but they're two separate facets which we need to look at. Now, social media is a reality. In our courts today, you have live tweeting by the minute. Every remark which is said by a judge is conveyed on social media. That's something which we needn't stop. We cannot stop. And obviously, we are at the receiving end on occasion. And sometimes the criticism is fair, sometimes the criticism isn't fair. But I do believe as judges, our shoulders are broad enough to accept the critique which people have of the work which we do. On technology that I speak of, the use of technology that we have employed in our courts is to broaden access to justice. For instance, we have 36,000 plus judgments of the Indian Supreme Court in English since the birth of the Supreme Court in 1950. Now, English is not the language which is spoken of in all courts, particularly the trial courts level. So what we have done is to use artificial intelligence or machine learning mechanisms for translating the judgments of the Indian Supreme Court in every Indian language which is recognized by the Constitution. So over 36,000 judgments of the Indian Supreme Court have been translated into Hindi. And they're being translated into every language, as I said. The purpose of doing that is to allow for citizens to understand the work of courts in a language which is intelligible to them. Because unless we do that, and if we continue to speak in a language which is alien to the language which people speak, which they speak at home, which they understand, the work which we do would not reach out to people. Another area of technology which we have been employing is video conferencing. We launched into video conferencing in a very large way during COVID, but video conferencing has come to stay because of the fact that, hybrid hearings have allowed the Supreme Court to become a Supreme Court not just of that location in Delhi, but truly a Supreme Court of the entire nation, where lawyers can address us from across the country. A litigant in a remote part of India can watch the proceedings in their case, e-filings, digitization of court records. And what we are doing in India is that we are ensuring that, conscious as we are of the digital divide, we are also providing for e-service centers in every court, in each of the 18,000 courts in India, to ensure that people, citizens, who do not have access to the internet can avail of our services by going to the nearest service center. But just as a final point, your first point on social media, yes, that is a problem, because very often every citizen on social media is a journalist with a view, and very often we are at the receiving end. And very often when I see the comments about what we have not said in the social media, I say, but well, we never said this, or we have been misinterpreted. But is that within our control, or are we just living in a society where so much lies beyond our control in terms of social media? But I always believe that the power of the good prevails over the power of the evil. And therefore, notwithstanding the flip sides of technology, notwithstanding the sometimes unwanted criticism of judges, overall, technology allows us to reach out to people and to explain to them of the seriousness with which we attend to problems of common citizens.
I look to the member on the front row, the press bench.
Thank you so much for your talk today. My question was, first I'd like to quote you from January this year. you'd said that the art of judging must be free of social and political pressure. So in context of your statement, what do you think has been the political pressure on the judiciary, particularly in the past few years?
Political pressure, in the sense, if you're asking me, is there pressure from the government? I would tell you that in the 24 years that I've been a judge, I've never faced a sense of political pressure from the powers that be, because some of the democratic traditions which we follow in India include that where we lead lives which are relatively isolated from the political arm of the government. But if you look at, if you're meaning in a political pressure in a broader sense of a judge realizing the impact of a decision which may have political ramifications, obviously judges have to be conversant with the impact of their decisions on the polity at large when you're deciding constitutional cases. That's not political pressure, I believe. That's an understanding by the court of the impact or the likely impact of the decision or the decision-making process, which the judge must necessarily factor into their consideration. Social pressure, many of the cases that we decide involve intense societal impacts. And as judges, I do believe that it's our duty to be cognizant of the impact of our decisions on the social ordering which we are ultimately going to effect.
Thank you. I look to the member in the front row there.
So first of all, thank you for coming here. It's a pleasure to hear your talk. Pendency of cases is a big issue in India, and especially in cases like the Negotiation Instruments Act, where it's a relatively easy case with clear-cut evidence. These cases often take like more than 10 years for the judge to give a ruling. This is often because of delay tactics employed by the lawyers and so on. So like in this environment, it's very difficult for the local businessman who has his payment pending, for example, to conduct business, and it puts them in a very desperate situation. So what can the judiciary do to improve this and to just make the situation better for the local people? Well, your question could probably consume an entire evening for us to find answers, but I'll give you some bullet point changes that we have, which we have made. The first is that the judge to population ratio in India is amongst the lowest in the world. We need simply more judges to adjudicate upon cases, and we are engaging with the government to increase the strength of the judiciary at all levels. Point number one. Second, we are trying to ensure that cases, that positions in the judiciary are not unfilled for a long period of time, and that the moment there are vacancies in the judiciary, that these should be filled up, beginning with the district judiciary and going up all the way to the Supreme Court of India. Third, I think the whole issue about judicial backlog is something which is not just of concern to the judges, but to the rest of society as well. Very often you would find that when a law is enacted, that law is enacted without a legislative audit of the impact on judicial infrastructure. Now, the law that you just mentioned, namely the check bouncing cases, the dishonoring of a check was essentially a civil dispute earlier, which was converted into a criminal offense. Now, what has happened, therefore, is that there has been a tremendous inflow of cases at the magisterial level involving these cases, which essentially was earlier a civil dispute and which has been now converted into a criminal dispute. I do believe it's important that when new laws are enacted, a legislative audit has to be done of the impact of the law on the existing judicial infrastructure. And if it is going to make a demand on the judicial infrastructure, we simply have to improve the judicial infrastructure which is available. Apart from this, just a couple of other things that we have done. We are using artificial intelligence for the categorization of cases, so that like cases involving similar issues can be dealt with by one court, one bench at the same time. Very recently, one of my colleagues dealt with a case involving land acquisition, where there were 750 cases which were disposed of by one single judgment. Now, that's an area where we can employ technology to ensure that cases which involve the same issue
can be dealt with, clubbed, and decided and disposed of together. So a whole host of measures have been taken to promote expedition in justice, but that's work in progress.
Thank you. I look to the member just there.
Thank you for the illuminating lecture. I would just like to know your thoughts on the basic structure doctrine and how can it be applied to probably going forward to more humanizing cases, and how do you look at the growth of such like judicial instruments in India?
Well, when the basic structure doctrine was enunciated by the Supreme Court in 1973, it was really enunciated in the context of the power of Parliament to make constitutional amendments. And the court in 1973, in a ruling of 13 judges, of course, in a divided court of 7-6, the court held that there are certain fundamental features of the Constitution which lie beyond the amending power of Parliament. And what the basic structure was has been elaborated upon by the court in that case and then in succeeding cases. We have used the basic structure doctrine at two doctrinal levels. One, while deciding upon the validity of a constitutional amendment. But second, which is a very interesting nuance on the basic structure doctrine, the basic structure doctrine has also been used as an interpretative tool so as to facilitate the achievement of constitutional objects, which would, for instance, further federalism, which is a part of the basic structure of the Constitution. So when I delivered a judgment in a GST case, the Goods and Services Tax case recently, we applied federalism as a part of the basic structure to so construe a new constitutional provision which had been brought in by way of an amendment so as to entrench and facilitate the fundamental federal features of the Constitution.
Look to the member right at the back.
First of all, thank you so much, sir, for coming to Oxford and sharing your views on same-sex marriage and how Supreme Court would set it. I just wanted to go back at this point and ask you, because when you come to law school, the first principle that we're taught is that if there's a right, there's a remedy. And what do people do if there's a gradual, development of the law? What do people do who have a right? So, for instance, to have a ration card, for instance, or to have some succession planning. What do they do in between when this law is evolving and before legislature comes up with something for them?
Well, undoubtedly, the basic principle of the common law is that where there is a right, there has to be a remedy. But all aspects of, there are some remedies which are available in courts. There are some remedies about reforming the law which lie somewhere else, namely in the other elected arms of a democratic state. Now, you gave the example of a person who needs a ration card and who doesn't have a ration card. There is a remedy which is available, which is you can move a high court under Article 226 of the Constitution and seek a writ seeking the performance of a public duty. If the sewage across, somebody's home has not been cleaned by the municipality, there is a remedy which is available before the High Court for that particular omission in the performance of a public duty by seeking a writ of mandamus, calling upon the local body to perform its duty. So to answer your question, where there is a legal right, there is obviously a remedy of approaching the High Court in the exercise of its constitutional jurisdiction under Article 226 of the Constitution, or the Supreme Court for the enforcement of fundamental right under Article 32. But the reformation of law does not necessarily always fall in the domain of the court, and that's something which we need to accept. Very often, there may be certain areas of the reformation of the law where legislative bodies have to intervene. And that is the point which we made in the same-sex marriage equality case.
believe 2 more questions now. I look to the member just over there, and I believe in the blue suit.
Thank you again for coming to speak to us. As India continues to gain recognition and authority on the world level, how do you think the court is going to change in its authority and power in terms of its influence in other countries? And what role do you think you might play or the court might play on that?
Well, you know, in an increasingly interconnected world, judges across jurisdictions are not speaking only to their own societies. Much of the work which we do is deeply influenced by what our peers are doing across the world. Likewise, I do believe much of the work which we do is impacting upon the work which is being done by our peers in other jurisdictions as well. I'll just give you an example. Though in the constitutional challenge to the validity of our biometric scheme, I was the lone dissenter in that case. My dissent has been accepted by a particular jurisdiction overseas. So judges, when they speak through their judgments, and that's the importance of the work which we do in the written text, that work speaks to the present, it speaks to the past because we are resolving disputes which have arisen in the past, and that work also speaks to the future about the kind of societies that we believe we should be moving towards. But we are also speaking not just to our own societies, but we are reshaping the dialogue between societies. And I think that really brings out some degree of synthesis in the work which judges are doing across jurisdictions.
Thank you. We will take one final question. I look to the member in the blue jumper at the front.
Hi, thank you so much for speaking to us today. So my question is about public perception and how the courts are received in India and whether there's generally a large sense of lack of trust. They feel like they're not operating honestly or are untransparent. And how have the initiatives that you've put in place, be that like technological access, changed public perception, or do you find that it's quite entrenched and difficult to shift?
Well, one indicator of trust, I believe, is the number of cases which citizens bring to the court. And going by just the scale of cases which are brought to our courts, I think the level of trust has to be high, because this is really the last frontier. And I do believe the courts do perform the role of being the last frontier. And one index, therefore, of the trust which we command is the number of cases which are filed in our courts, which is unprecedented in terms of jurisdiction. The work which the Indian Supreme Court does, for instance, is not just the work of a constitutional court, but a court of appeal. And one of the criticisms which we have faced is about the width of our jurisdiction. But the framing mothers and fathers of our Constitution did provide for a broad sense of jurisdiction to the court, because this was always intended to be a people's court. It's not one of those rarefied courts which only speaks about constitutional doctrine, but it's a court which touches the lives of citizens and their day-to-day problems. And I think that, in a sense, is the strength of our system. Though it's obviously a source of the backlog which we face in courts. But we can do a lot more, and we are trying to do that, to entrench the sense of public trust and confidence. And the best way, I believe, is for courts to be transparent, for courts to be accountable to the people. Because we are not accountable in that sense to democratic elected institutions like Parliament is. But we can do a lot to make ourselves more transparent, which we are trying to do. And we can also add to our own accountability. And transparency really can be brought about by extensive deployment of technology, which allows citizens to access the nature of the work which is being done in the courts.
And just lastly, I'd like to ask a question which we ask all of our guest speakers. If you were to leave our members with one piece of advice today, what would it be?
Well, somebody asked me just a short while ago that when you lay down office one day as a judge, what would you like to be looked at for or remembered for? And I reflected on that, and I think I'll leave all of you with this thought, that have I done something in the course of my work as a judge in dealing with the problems of real human beings which have come to our court to leave their lives in a better situation? And have we, in working our way through the complexities of the law, ultimately made our society more livable, more humane, more accessible, more tolerant, more compassionate? A society which finds solutions to disputes through ordered discourse. There's a very distinguished South African judge who's written this beautiful book called The Strange Alchemy of Law and Life. And he says that the great merit of the work which has been done by the Constitutional Court in South Africa is to substitute what was being done by perhaps a bullet by reason. And I think that is the key, that's the key foundational structure of our courts, that by allowing for diverse strands of conflicting opinions, we have provided a space for people to engage in reason, by providing them a space to engage in dialogues, and by lending our ears, our institutions, our time, the physical space, and now the virtual space of the courts, to orderly dialogue. I think we are trying to protect some of the most fundamental values of democracy.
Thank you. And before we end on a personal note, I would like to thank Tanvi Dubey, an advocate in the Supreme Court of India,